Good evening. This comment was left for me by William Simmons on my last video about Stunt Dummy and Beware Mouse. And I'm going to go through this kind of fast. You can see the text of the statement up here, and you can read it at your leisure so that you can be assured that I'm not taking anything out of context, but I'm going to breeze through it really quick. First, we start off with lies, damn lies, and statistics. That's a Samuel Clemens, Mark Twain quote. There are over 50 titles in the U.S. Code of Laws. Yeah, there are, but the reason why there are over 50 titles in the U.S. Code of Laws is because there are lots of topics, and they separate these things out by topic. So they don't want to throw armed forces in with bankruptcy. It doesn't make sense. So they separate them out for convenience. It's so that if somebody starts talking to you about 18 USC, you know they're talking about crimes and criminal procedure. It's just a category kind of system. And then, more than 30,000 pages. Well, it's a big country. There's lots of things to regulate. So that doesn't really, that seems like a big number, but that's not really a big number. And how big is the page and how small is the writing? And then he goes on to say that the federal government has even lost count of the number of federal crimes contained therein. I would love for him to cite a source on that. But then he goes on to talk about the Lacey Act, and he gives us this quote. Now, a couple things. First of all, this quote right here, well, the Lacey Act starts at 16 U.S.C. 3371, not 3370, but that's a niggling little detail. But this quote right here is from the civil penalty portion, penalties and sanctions, civil penalty. This is his quote right here. So this is not necessarily a crime. A civil penalty isn't a crime. It's the reason why they call it a civil penalty as opposed to a criminal penalty. That should make it clear to you that it's not a crime. It's a civil penalty. Most of the things in here, most of the things in the law are going to give you civil penalties. So it doesn't make it a crime. It makes it unlawful, but it doesn't make it a crime per se. So maybe I'm being a little too lawyerly in the language. But the second thing is that you probably should have started off quoting what the actual crime is. But then he goes on to say, did you know under certain circumstances it's a federal crime to possess an undersized lobster tail, even if you kill the lobster acting in self-defense? And that's, it sounds fun. And I've heard this before. It used to be going around on conservative talk shows. And then he quotes U.S. v. McNabb, and this is a quote from it. And he says, how can anyone know all the U.S. laws, let alone the laws of the world, lol? The U.S. government does not enforce the laws of the world. International laws, I guess they do. Treaties, which are kind of laws that two nations have agreed on enforcing between them, they do. But like the U.S. isn't going to enforce Honduran law like he is suggesting here. And we're going to kind of go over it. This is United States versus McNabb, and the language he quote, the first issue we'll address right here. It's not a very interesting case other than the lobster tail issue that people latched onto. The case is from the Lacey Act. Let's go over the Lacey Act real quick, just so we know. We'll start off with 3371. This is where the Lacey Act starts, and in 3371 they define person to be an entity subject to the jurisdiction of the United States. You could read it all right here. It's got to be an entity subject to the jurisdiction of the United States. So with that in mind, when you read the actual prohibited act portion, it makes it a little more clear. It's unlawful for any person who happens to have to be subject to the jurisdiction of the United States to import, export, transport, sell, receive, acquire, or purchase in interstate or foreign commerce. So whatever you do, it has to be done through interstate or foreign commerce, or in interstate or foreign commerce, which would preclude killing a lobster acting in self-defense. So it is unlawful for any person subject to the jurisdiction of the United States to import, export, transport, sell, receive, acquire, purchase in interstate or foreign commerce any fish or wildlife taken, possessed, transported, or sold in violation of any law or regulation of any state, or in violation of any foreign law. So the way that is interpreted is that the wildlife or fish taken in violation of state law means it would have to be taken from that state. So if you illegally fish, I don't know, trout out of season in Montana, and then you proceed to sell that in interstate commerce or transport it through interstate commerce or whatever, then you may have violated this particular code section. But if you're fishing in California, which doesn't have the same prohibition on fishing trout at that time of year that Montana does, then the fish you take would be lawfully taken, and thus you would not be violating 16 U.S.C. 3372. And you can see that in McNabb, because the background for McNabb, this is from the Department of Justice. This is their opposition where they actually lay out what was going on. David Henson McNabb owned and operated a fleet of lobster fishing boats that harvested Caribbean spiny lobster in Honduran fishing waters. So he's a United States citizen who is operating in Honduran fishing waters. Because he's in Honduran fishing waters, then all of these various laws from Honduras are in effect, and if he doesn't comply with them, he is taking these spiny lobster unlawfully. So in violation of those requirements, McNabb's fleet harvested lobsters, right? And then what did he do with them? He took them to Bayou La Batre, Alabama. That is a very pretentious name for a city in Alabama. For delivery to Sea America Corporation, blah, blah, blah. And then they ended up getting sold in commerce throughout the United States. So what Mr. Simmons is suggesting is not correct. It is a general intent issue. You have to have a general intent mens rea. This isn't strict liability. So after that, Stunt Dummy thinks he has a partner who was making sense, I guess, and he says the U.S. has extraterritorial jurisdiction. Well, let's look at the U.S.'s extraterritorial jurisdiction. This is 18 U.S.C. 3042. We're in crimes and criminal procedure. It's 18 U.S.C. This has got to be the worst sentence ever written. Section 3041 of this title, which is Power of Courts and Magistrates, shall apply in any country where the United States exercises extraterritorial jurisdiction for the arrest and removal therefrom to the United States of any citizen or national of the United States who is a fugitive from justice, charged with or convicted of the commission of any offense against the United States, and shall also apply throughout the United States for the arrest or removal therefrom to the jurisdiction of any officer or representative of the United States vested with judicial authority in any country in which the United States exercises extraterritorial jurisdiction of any citizen or national of the United States who's a fugitive for justice, charged with or convicted of the commission of any offense against the United States in any country where it exercises extraterritorial jurisdiction. So two things to note. It has to be an offense against the United States. So it's U.S. law. This extraterritorial jurisdiction is enforcing U.S. law, and it is enforcing it against a citizen or national of the United States. So if you flipped that script and pretended that this was a Canadian law, and I don't know Canadian law, I don't care about Canadian law, to be quite honest with you. But if you made this, if you pretended like Mouse was Canadian and Stunt Dummy was an American and talking about extraterritorial jurisdiction, then it would be clear to you that the U.S. is not saying through this that they have jurisdiction over a Canadian violating U.S. law in Canada. It's over a U.S. citizen violating U.S. law. So Canada might be like, well, this is a Canadian citizen violating Canadian law. Maybe that's the way their extraterritorial jurisdiction works. I don't know. Again, I don't care about Canadian extraterritorial jurisdiction. Then he goes on to say, so does Canada. No one cares what Canada does. It's not like Canada can enforce shit against the U.S. It recognizes crimes that takes place in the other country, and from what I've read, the U.S. does consider conspiracy worthy of its use. First of all, that is not an appropriate use of an apostrophe there. But again, conspiracy to what? I mean, conspiracy to jaywalk, conspiracy to throw a surprise party, conspiracy to wear a Hawaiian shirt on Friday. I don't know what you're talking about. and neither do you. So think about that. Finally, this is Morrison v. National Australia Bank. And why are we talking about this? Well, we're talking about this because we want to go to the opinion and we want to go down to Section 3. It is a long-standing principle of American law that legislation of Congress, unless a contrary intent appears, is meant to apply only within the territorial jurisdiction of the United States. When a statute gives no clear indication of an extraterritorial application, it has none. Thanks for watching and have a great day.